Good evening, everyone. I hope you're doing well. This is for Saddleback College students enrolled in HS 119, Introduction to Criminal Justice. I finally finished grading your midterm examinations. Yay! Anyway, so I want to just give you a couple of statistics that I thought might be helpful. You guys were given 24 hours to complete 11 short essay questions and to answer 10 multiple choice questions and 10 true-false statements. The average time it took for a student to complete the exam was 3 hours and 26 minutes. And the average overall score was at 87%. So that's a high B. You guys did really well. Congratulations. That's pretty rad. I'm only going to go over a couple of the questions where more than 5 students got them wrong. There weren't enough students that got questions wrong where I had to throw out a question. So in any event, and this is in regards to the true, false, multiple choice questions. True or false? Criminal justice policy was initially based on revenge and informal social controls. Currently, our criminal justice system philosophy is that of public safety, rehabilitation, and reintegration. The answer is true. Some of you got that wrong, and that was something that was clearly stated in chapter 1 of the textbook. Let's see. True or false? Police are the gatekeepers of the criminal justice system. That's true. Police are. Whether or not an officer decides to arrest someone will determine whether or not that individual is entered into the criminal justice system. Let's see here. This was a multiple choice question. According to our textbook, it is important to police the police so as to uncover misconduct towards the most vulnerable, which are the mentally ill, immigrants, and the elderly. The correct answer was all of the above. Some people only chose the mentally ill, but our textbook was very specific about those protected groups of individuals. Let's see here. Internet crimes. Internet crimes didn't exist 30 years ago, crimes such as cyberstalking, child porn, and identity theft. While technology has advanced, our laws have not caught up to such advancements. Currently, our laws lack identified boundaries and clear definitions of what constitutes an internet crime. The answer was all of the answers. This is what makes internet crimes unique. They haven't been around for a significant amount of time. Our laws haven't caught up with the advancements of technology, and we lack clear boundaries because anyone from anywhere in the world can engage in an internet crime. So it's hard to track where individuals are at the time when they're on the internet engaging in criminal activity. Another true-false question, and I believe it was on page 112 of our textbook as well. Per our class, I'm sorry, not true-false, multiple choice. For our class discussion, and our textbook, when considering cases that proceed to criminal trial, so the cases that are not resolved by way of plea negotiation, the cases that actually go to trial, how many cases are estimated to actually proceed to trial? Your choices were 50%, 80%, 10%, and no cases. The correct response was 10%. It's estimated per our textbook that 90% of cases are resolved by way of plea negotiations. And question 18 was a multiple choice question, and it was the crime control model focuses on the reduction of criminal behavior. Conversely, the due process model emphasizes the following. It emphasizes the protection of rights of defendants. It emphasizes the swiftness and certainty of case outcomes. None of the answers are all of the answers. The correct one was it emphasizes the rights of defendants. That was a question that I made a mistake on. I went back and corrected it, and then your score was corrected to reflect that. So that, in a nutshell, were the true, false, multiple choice questions. Oh, one more multiple choice. Prosecutors and discretion. Remember, discretion is to act or not to act based on training and prior professional experience. So the question says, Prosecutors often work behind the scenes, yet they also represent the public in courtroom hearings on behalf of the state. Prosecutors exercise discretion by engaging in plea negotiations if a case does not proceed to trial, making bail recommendations to the court, files or deciding not to file charges against defendants and offenders. All of the answers. The choice was all of the answers. Some of you only indicated that they engage in plea negotiations or that they decide to file or not to file a case in court. It's those two plus making bail recommendations. Again, this was per our textbook. So make sure to be mindful of that. Prosecutors can exercise discretion in 3 ways. Okay, very good. I'm going to talk now about the short answer questions. And I'm not going to go into too much detail because we had a Zoom review, we had a recorded Zoom review that you guys could access while you were taking your exam. I will say this about the grading. I did grade a little more, you know, I was a little more hard with the grading for a couple of reasons. In our study review that was recorded via Zoom, I gave you all of the short essay questions. I gave everyone all 11 questions. I also provided you with the expectations as to what the answers were. Additionally, you guys were given prompts in that I boldface typed a lot of the words. And in the Zoom review, I even cited sources such as our slide presentation, specific slide numbers, and specific page numbers from our textbook. So, for example, I noticed some students only spent 38 minutes in Canvas on the midterm, excuse me. And I noticed some students spent 12, 15 hours on it. Maybe they walked away from it and came back. But I gave you everything you needed. So if you feel like I graded you too harshly, it's because I gave you everything in advance. I even gave you a tip of writing out your short essay questions, your responses in a Word document or a Google document, so that way when it came time for the exam, all you had to do was copy and paste. And some of you, I can tell, did that. Some of you didn't do that. Some of you didn't even address some of the questions at all. So I did grade with a higher level, a higher expectation, because I gave you so much in advance. Okay, so question 21. Please define the following in your own words: causation, direct cause, concurrent cause, proximate cause, and harm. This could be found in Chapter 2 on pages 32 through 33 of our textbook. Causation is when an individual causes a result. Direct cause is when an individual's behavior is the direct cause of harm. So I have a knife and I stab you. My action caused your stab wound. Concurrent cause: 2 behaviors at the same time that result in the same harm. I love to use the Mac Miller case. Mac Miller overdosed on drugs 2 or 3 years ago, I believe, and he received his drugs from multiple drug dealers. So we have drug dealers that have been arrested and charged with federal crimes as a result of Mac Miller's death. And essentially, multiple drug dealers provided him with different drugs, the drugs in which he overdosed on. And so the law allows for the arrest of the individuals who are responsible for supplying him with those drugs. So we have multiple drug dealers. We have 2 drug dealers that gave different drugs, the same drugs, to Mac Miller. Mac Miller ingested some of those drugs. They were Oxycontin, cocaine, and Xanax. He ingested some of those drugs and he overdosed. So the 2 drug dealers are being charged with his death because they contributed. They didn't make Mac Miller take the drugs, but they provided him with the drugs that ultimately led to his death. And proximate cause: something other than the individual behavior. The individual's behavior causes the ultimate harm. So our textbook references a situation where an individual takes a gun and shoots somebody in the foot, and the individual later has to go to the hospital and have an operation, have a surgical procedure done on his or her foot. And in the course of the operation, the victim dies. So the individual who shot the victim in the foot could ultimately be responsible for their death, because if we had not shot that individual in the foot, they wouldn't need surgery, and if they weren't in surgery, it's not likely they would have died. So that is concurrent cause. And harm, I was looking for two definitions. Our textbook provided a definition, and we talked about another definition of harm during one of our Zoom sessions and during the midterm review as well. So per our textbook on page 33, it starts on page 32 and it goes into page 33. Harm must be present for criminal liability. Harm must be caused to a person, place, or thing. And typically harm is absent in drug use, but from a social perspective, drug use can negatively impact communities and can have psychological harm on the families of those individuals who use drugs. So those are different types of harm, different examples of harm. Some of you wrote about psychological harms, community harms, societal harms. Those were awesome responses. Question 22, what are the three primary responsibilities of police? What is the role of police in our society? What is and how is discretion used or applied? Please explain. The answers to primary responsibility of police and the role police play in our society are from chapter 3, pages 55 to 59. So the three primary responsibilities of police are law enforcement, order maintenance, and service. And on page 57, you will find what is the role of police in our society. Police must operate in the tension between a rapidly changing social conditions and a conservative, slow-to-change legal environment. So as our society changes and grows and our behavior is modified, our laws aren't necessarily congruent with our behavior and where we are in society. And we're seeing that right now, aren't we? With some of the protests and civil unrest, that's what's going on. Our laws aren't necessarily congruent or congruent with what's going on in society. And discretion. Discretion was from chapter 1, pages 16 and 17 and 19 through 21. So discretion is whether or not we act, to act or not to act. And we make our decisions based on our training and our past experience. We also make it on certain case dynamics, right? Depending on the needs of the individual we're dealing with and the needs of the community. We can relate discretion as we could the letter of the law and the spirit of the law, right? We talked about how we get pulled over by police, we're contacted by police. They have the option of issuing us a ticket or giving us a warning. They have the option of taking us into custody or another alternative. Say you're a juvenile and you have the alternative of the police calling your parents and having them pick you up to avoid being arrested. Okay, very good. You guys did great on that one. Question 23. In your own words, what are specialized/collaborative courts? What is involved in specialized or collaborative courts? And what does research say about these types of courts? So a three-part question. So this could be found on pages 110 to 112 in chapter 4 of our textbook. And again, you could have gotten these answers from our textbook, from our slides presentation, and or from the embedded links that I provided in our slides presentation. These responses that I wrote down that most of you got were basically from the textbook. Collaborative courts are for special needs offenders who are repeatedly in court for issues such as drugs, mental illness, and domestic violence. Specialty courts or collaborative courts are exclusively for certain types of offenders. So in addition to these charges, we look for other qualifications and characteristics. Does the individual have the ability to comprehend and understand and follow what's being asked of them? Are they likely to comply? Do they have support? If they don't have support, are we going to be able to help them connect with support? Drug courts, mental health courts, and domestic violence courts, for example, provide a treatment emphasis. So the goal is rehabilitation with components of treatment throughout the court process. It involves a collaboration of various agencies such as the prosecutor or district attorney, the public defender, maybe the mental health care agency, maybe a housing agency, maybe a veterans administration if we're working in a veterans court. And there's a plethora of intermediate sanctions. So going back to jail is not necessarily the only option. There are multiple options that we can engage in when it comes to intermediate sanctions in collaborative courts. The idea of treatment over punishment and the use of community treatment programs are central to these types of courts. And what the research says is that, typically speaking, collaborative courts produce healthy, positively contributing individuals who have lower rates of recidivism. And what the research also indicates is that because these courts are largely voluntary and that participants have to be willing and want to be a member of this court, because they're willing and they want to be there, that could be one reason why they have such low recidivism rates, because the individuals have an authentic desire to be there and to do the work that's required to effect change. The only one that had mixed research results were the domestic violence courts, and that was because domestic violence courts were not able to provide as many services, and they weren't able to track recidivism the same way as in drug courts and mental health courts. Okay, and a lot of you used the resources that I embedded in our slides presentation, and a lot of you referenced the research results from the Orange County Probation Department and the California Superior Court as it relates to the success rates in Orange County. Orange County's recidivism rate is low in drug court, with a 70+% success rate of individuals who spend at least 5 years after completion of drug court, not committing any more crimes, not being rearrested, not being back, not appearing before a criminal court again. So that's really exciting that you guys referenced that. Question 24, in your own words, please describe the different types of crimes our textbook teaches us about. Please provide one example of each. So some of you wrote about the difference between a felony and a misdemeanor, mala in se. That is fabulous, and I'm so glad you guys did that. I was specifically referring to the types of crimes that our textbook talks about in Chapter 2, pages 33 through 36. And I don't know if some of you caught on to this, but I bold-face typed different types of crimes to match the heading in our textbook. So I don't know if you guys caught on, but throughout the exam, I bold-face typed keywords or ideas or theories that I wanted you to pay attention to help you navigate your textbook and the resources I gave you. So keep that in mind for the final. So the 5 crimes our textbook teaches us about, the 5 types of crimes, are crimes against the person, crimes against property, crimes against public order, drug offenses, and white-collar crimes. Crimes against the person, rape, murder, kidnapping. Crimes against property, larceny, burglary, shoplifting, grand theft. And on a side note, some of you indicated shoplifting as a victimless crime. That is false. Shoplifting is a crime against property, okay? Because remember, harm is when there is causation of harm to a person, place, or thing. And when we shoplift, we're shoplifting from a store, and a store is a thing or a place. So please be mindful that shoplifting is not victimless crime. Crimes against public order will be some of our victimless crimes, such as prostitution, drug use, and gambling, but it also includes other crimes that are not victimless crimes. Nudity in public, drunk in public. Those are not necessarily victimless crimes. The victim is society. The victim is a passerby who has to see that. The victim is a child walking with their mom and dad who sees an individual nude in public. So some of you again listed those as victimless crimes. Those are not victimless crimes. So be mindful about crimes against public order. Drug offenses. Again, drug use, distribution, manufacturing, sales, possession for sale, things like that. And white collar crime. So those are going to be crimes that are performed through the course of someone's job or professional ranking. So typically those are going to be things like tax evasion, price fixing, money laundering, things like that. Very good, you guys. Okay, number 25. Please explain the chain of command. In your opinion, what is the value of a chain of command? Please explain. So the things we were looking for from chapter 3, page 65, the chain of command is a hierarchical form, and information from the front line, like the bottom of the pyramid, remember we talked about in our midterm review Zoom session, the bottom of the pyramid are going to be the bottom of our pyramid is going to be our frontline workers, and it narrows as we go to the top of the pyramid because as higher ranking officers hold their positions, there are fewer higher ranking officers as we get to the top. So information from the front line is distributed to the higher ranking positions through the chain of command. So the example I gave you in our Zoom session was when I was a probation officer. I had a supervising probation officer, and he had an assistant division director. My assistant division director had a division director. My division director answered to the chief deputy, and the chief deputy answered to the chief of our probation department. So if I ever had information that had to go to the top, I took it to my supervisor took it to the assistant division director, and so on. I did not go around that and go straight to the top. I followed the order of hierarchy. When orders are conveyed, they go from the top down. We call it top-down management. I gave an example of when the orders come down, they're not always fun, and for those of us working on the line on the bottom of the pyramid, we feel like we're being dumped on sometimes because we have to make the changes that our administration wants us to make, whether we want to do it or not. And those directives come from the chief to the chief deputy, to the division director, to the assistant division director, to my supervisor, and then finally to me. Voila. The hierarchy chain of command is a military structure, and the benefit, as we talked about in our Zoom review, was that it is an organization that avoids chaos and anarchy. It holds individuals accountable, and it also provides a sense of accountability and responsibility to the public. The public will know that in our organization, this is how our management is organized. This person answers to this person is responsible for this division, and it's a way that we can demonstrate a consistent flow of information from the top down and the bottom up. Very good. Let's see, 26. What is victimless crime? Please provide 3 examples. Who/what are potential victims of these types of crimes? Okay, so essentially victimless crime is there's no complaining party. It's individuals who are engaging in crime consensually, and there's no complaining party. I don't like to say there's no victim, because even when we talk about victimless crime, there is a victim in some way, shape, or form. Maybe not directly, but indirectly. So if you're asked again in the future, what is victimless crime? Please refer to it as no complaining party. And I think I gave the example of me as a sex worker engaging in prostitution. I trade sexual behaviors for some money. I'm not calling the police and saying, hello, I just engaged in prostitution. I just accepted money for this sexual act. It doesn't work that way. So when we talk about victimless crimes, there is no complaining party. Some examples: prostitution, illegal gambling, and drug use. And those were examples we talked about in class during our Zoom session as well. Potential victims. The individual engaging in the victimless crime, so the person who's gambling illegally, the person who is the sex worker engaging in prostitution, and the individual using drugs, they're potentially harming themselves. Family members and friends of those individuals can be victimized. our community and society can be victimized. A lot of you used the example that we talked about in our class Zoom session and our recorded Zoom session for the midterm review. You shared the example that I gave to you of our homeless population that was living along the Santa Ana riverbed. A lot of them were IV drug users, and they left behind their needles and human waste and blah blah blah, and the county had to spend millions of dollars to clean it up, and that the used and exposed hypodermic needles present a public health threat, a public health concern to society. So that is society is a potential victim. Individuals are a potential victim. Very good, you guys, very good. 27, in your own words, please describe police corruption, excessive use of force, and the blue wall of silence. How are these related? Please explain. This was from chapter 3. Police corruption was on page 72, excessive use of force, page 73, and the blue wall of silence, page 76. So essentially, police corruption is when you use your position of power and authority for personal gain. Excessive use of force is when you are using more force than necessary. So a lot of you use the example of the George Floyd incident where the officer held his knee on George Floyd's neck for an excessive amount of time. That was a good example. And following our use of force continuum, officers are only supposed to apply the force that is necessary to gain control. So if someone is coming at you, we have a bunch of different tools that we can use as officers to de-escalate the situation and control the situation, but it doesn't always require unholstering your weapon and pointing it at a suspect or an individual. Okay, again, you use your discretion, the case dynamics, the individual, what's going on with them. Excessive use of force is using more force than necessary, and typically when you use excessive force, you are causing harm to that individual, and we do not want to intentionally cause harm. And the blue wall of silence is basically, it's a informal code of keeping your mouth shut or writing your report in such a way to support bad behavior from your partner or a fellow officer. It also has to do with avoiding confrontations with supervisors, staying under the radar, taking a code of silence against the wrongdoings to protect your partner rather than do the right thing and speak up. These are all related because these are an abuse of power. I didn't address this in class, but I addressed it in our midterm review, and that was recorded via Zoom. I talked about abuse of power as being like an umbrella. And police corruption, the blue wall of silence, and excessive use of force, those are all an abuse of power, and they fall under the umbrella of abuse of power. And they typically all go hand in hand. If we are an officer and we're engaging in corruption and bad behavior and our partners know, it's likely they're going to keep their mouth shut because they don't want to get involved. They want to keep the peace. They want to keep it mellow. They want you to know that they have your back because in the future you may need to do the same for them. Okay, very good, you guys. You did a great job on that. 28, what is Marsy's law? Please list 3 rights. And why is it important to provide victims with these rights? Okay, so another 3-part question, okay? So Marsy's law was based off of an individual named Marsy, and she was murdered. And a week after the murderer was in custody, he was out on bail, and Marsy's family did not know. They saw him in a supermarket, and as a result, they worked with California legislation, and we have now what's called Marsy's Law. It was the foundation for the for the Victims' Bill of Rights in the state of California. It was an amendment added to our state constitution. And as a result, California became the model for other states throughout the United States, and I think all but 11 or 13 states right now have a Victims' Bill of Rights. So I'm not going to go over all the rights, but many of you were really good about identifying 3 rights. You can find those from Chapter 2 slides presentation, slide number 13, and also from Chapter 1, page 21, slide number 17 as well. Slide number 17 from Chapter 1 has the California Victims' Bill of Rights for the state of California. And Chapter 2, slide number 13 has the history and embedded link on Marsy's Law and a little blurb about her family and their history with Marsy's Law. Why is it important to provide victims' rights? A lot of you gave really good reasons, but some of you are missing the most important reasons, okay? Like many of you wrote, we want to make sure victims are kept safe and feel comfortable. We want to make sure they're not re-victimized. We want to make sure that they're given equal rights to that of the offender or the defendant. But more importantly as well, is victims are typically the first to notify law enforcement that a crime has occurred. So if we're relying on victims to notify us when there's a crime, we need to be respecting them and giving them the same rights and opportunities that we are giving to an offender. Furthermore, victims are citizens, and citizens are part of the 4 C's that make up criminal justice. Remember? Citizens, cops, courts, corrections. And like that stool, I can't draw or whatever, but anyway, the stool that I gave you, the image I gave you for our very first module, Chapter 1, each of the 4 legs represents one of those 4 C's. So without one of those 4 C's, we have an incomplete justice system. We have a system that cannot function properly. So it's important to remember the value that victims represent, okay? 29, please define the following: indeterminate sentencing, determinate sentencing, arraignment, bail, and restorative justice. Woo, okay. So indeterminate and determinate sentencing were from Chapter 4 on page 107. We went over this in our in-class Zoom session, and it's also in our slide, our midterm Zoom session as well. So indeterminate sentencing is the focus is on rehabilitation and incapacitation. It's tailored to meet the needs of the offender. There is a minimum and a maximum range. For example, 2, 3, or 6 years in custody. And the individual's release from custody is a decision made by the parole board at the state level. So some of you indicated that the sentence was handed down from the parole board. That's incorrect. Only a judge can order a sentence or a commitment to custody. Only a judge. What the parole board does in the case of indeterminate sentencing is based on an offender's time in custody, good time, any time they engaged in a program or something, they can receive custody credits. At that point, the parole board makes a decision whether or not to release someone. But the parole board does not determine the sentence, only the judge does. Okay. We also talked about how indeterminate sentencing was a common practice at the state level. And in our in-class Zoom session, I talked about how this is the most common sentencing structure in the state of California. I described it as kind of loosey-goosey in that not everybody goes into custody with an indeterminate sentence. We can use things like parole, we can use community supervision like probation instead of sending someone to jail, and that falls under indeterminate sentencing, okay? Determinate sentencing is more of a law and order type philosophy. It is a specific period of time, what we call a flat or fixed sentence, and we use terminology such as mandatory minimums and maximum terms in prison. This is a common sentence structure that's used at the federal level. So you might see something like a mandatory minimum of 10 to 20 years in federal prison with the possibility of parole. And so this is a sentence that is not based on rehabilitation. It's not based on the needs of the individual. We're taking the crime and we're punishing the crime. We are not helping the offender, okay? Arraignment and bail can be found on also Chapter 4, pages 100 to 102. We talked about this in our in-class Zoom session. So arraignment is the first appearance in court. It is where individuals are advised of the charges being brought against them. It is an opportunity for the defendant or the offender to enter a plea of guilty or not guilty, and it is an opportunity for the court to decide whether or not to grant someone bail. Okay, not a lot, but some of you put down that the arraignment was after the preliminary hearing, and that's incorrect. The preliminary hearing is before the trial. Okay, the preliminary hearing means you've already been arraigned, you've already entered your plea, you may be in custody, you may be out on bail, but preliminary hearing is down the road. Arraignment is the very first appearance, being notified of your charges, entering a plea of guilty or not guilty, and the court deciding whether or not you're eligible and suitable for bail. Bail, money paid to the court as a promise that you will appear for future court proceedings. It's based on the nature of your offense and the dynamics and characteristics that you possess. Do you have a lot of ties to the community? Do you have a job? Are you the main supporter for your family? You might be more likely to be let out on bail. If you're unemployed, if you're homeless, if you have a history of substance use or untreated mental health disorders, you might not be a good candidate for bail because you might not be able to comprehend or understand that you need to come back to court. You may not have transportation, things like that. So a lot of factors go into bail. And restorative justice, page 113 from chapter 4. Restorative justice enables defendants, offenders to understand the harms that they have caused and to make it right through acts of community service, things like this, or letters of apology to victims. Restorative justice allows for victims to provide input. Victims are entitled to restitution. Offenders will come to understand why they need to pay restitution and what the value of restitution is. And it has a heavy involvement, restorative justice has a heavy involvement of community programs. So it's about getting the offender to understand their victim may not just be a human being, it may actually be the society or community where the victim lives. And so we try to get the offender to understand it's much bigger than just victimizing one person. Their behavior impacts an entire community. So for those of you who wrote down that it was focusing on rehabilitation and that was all you put, I didn't give you full credit because it's more in depth than that. And sometimes when appropriate, we use restorative justice to bring an offender and a victim together when it is safe and appropriate and when the victim is okay with it and open to it. Okay? We never put victims in harm's way, but we do give victims as many opportunities as possible to have input and to speak up when we talk about restorative justice. Okay, second to last question. Please define the following constitutional rights. Okay, there were several places for you guys to find these, and some of you did not answer these completely, so I had to take points away. So if you only gave me one answer for, say, the Fifth Amendment, I did not give you full credit for that response because there's 3 parts to the Fifth Amendment. There's 3 parts to the Sixth Amendment. There's 3 parts to the Eighth Amendment, and there's at least 2 parts to the 14th Amendment. 3 parts, many parts, anyway, and a lot of you lost points on that. So these answers could be found in chapter 2, pages 44 to 45. Our textbook has a box 2.2, and it lists all of the constitutional rights. And then also on pages 46 through 51, our textbook goes into more depth for each amendment. So our Fourth Amendment is the right to be free from unnecessary and illegal searches and seizures. The Fifth Amendment, there are 3 components. Double jeopardy, the right to be free from double jeopardy. You can't be tried more than once for the same crime. The right to plead the Fifth or remain silent and avoid self-incrimination. And the right to a grand jury. So if you only gave me one of those 3, I didn't give you full credit for that. I only gave you partial credit. Sixth Amendment, the right to counsel. The right to a speedy trial and impartial trial, the right to a jury trial. Okay, 3 components. A lot of you missed that this was our right to have legal representation, the right to counsel, super duper important. So again, if you only listed one of those aspects of the Sixth Amendment, I only gave you partial credit. Eighth Amendment, to be free from excessive bail, excessive fines and fees, and to be free of cruel and unusual punishment. A lot of you did not include all three, so again, you only received partial credit. And the 14th Amendment, it's our right to due process. We have the right to exercise every single right that's afforded to us. That's called due process. Making sure that your rights are being afforded and that you have the opportunity to exercise those rights. As a citizen, you are guaranteed these rights, and regardless of what state you are in, these rights apply to you. So again, if you're missing any of that, I could not give you full credit. And then what is the value of knowing and understanding these rights, even if you don't become a criminal justice practitioner? A lot of you did really good. You nailed it. You talked about just knowing your rights as a citizen, because as a citizen, we are part of the criminal justice system, right? And then a lot of you talked about how in criminal justice, these are the rights that are the foundation of how our system operates. You guys nailed it. Good job. And our last question, what did you learn about the opioid crisis after watching the two videos? What solutions can you think of to help better address the opioid crisis? Those two videos were from our Chapter 3 slides presentation on slide number 13. There were two videos. Some of the takeaways I wanted you guys to be aware of was, number one, that fentanyl is out there. If you are using drugs recreationally, you need to be mindful that fentanyl is out there. It doesn't take much to ingest for it to wreak havoc and be fatal. You can inhale a small particle. A small particle can be on your skin. It can be absorbed